Okay, well, thank you so much, everyone, for coming out this evening to listen to our presentation on the sandwich years. For those of you who don't know me, I'm Tammy McLeod, and I'm Director at Davenport's Law. And tonight I'm presenting with Stephanie Irons, who's also recently been made a Director at Davenport's Law. So when we were putting together this seminar, we were trying to think of something relevant. So as many of you will know, there's lots of familiar faces in the room. We have done seminars about trusts in the past, which have been well attended and everyone's enjoyed those. But we're seeing a real theme within our practice around what we are calling the sandwich years. And I think that I have seen that name bandied around before. It did stem from a book that I'd been reading in book club, which was called Sandwich, and it was about a woman who was on holiday with her elderly parents and her children who were in their mid-20s, and she just felt sandwiched in between. And I thought that was just a really apt description for many of the people that we are seeing who have got ageing clients, children who are coming through needing extra help in a different way from when they're really little, and also perhaps experiencing some changes in their lives as well where extra legal help's needed. So that's how we came up with the navigating the sandwich years as being the theme of this seminar. So what we're going to cover, so Stephanie and I are going to tab in and out, and the seminar will run for about an hour. There'll be time for questions at the end, so we'd probably rather wait and keep those at the end because we could do a seminar on each of these topics by themselves, so there's lots and lots of information to cover here. So first of all, I'm going to cover asset structuring, so I am going to talk a little bit about trusts because that's my core of what I do and what I still love the most. So I'll talk a little bit about trusts, about why people still might have trusts, why they might not have trusts, and just briefly on things that you can do to vary or restructure those sorts of structures if you've got them, and then some about wills and powers of attorney, which are my favourite thing. So I'll talk about that. And then Stephanie has got the unenviable job, perhaps, of talking about navigating separation and divorce. And what I have to say, I've never seen so much in my nearly 30 years of practicing law, so much separation work right at the moment. So probably a sign of economic times and turbulence over the last few years. But so I'll leave that with Steph. Then I'm going to talk about helping adult children into property and the various ways that that can be structured. And then lastly, Steph's going to talk about guiding ageing parents, and then we'll do a wrap up at the end and take any questions. So, shall we take it away? So, asset structuring. So the first thing that we're going to talk about is trust. If you see me looking down here, it's because we've got a screen down here, which is mirroring what you've got up there, so it's easier to look down here. So trusts. So there have been quite a few changes in recent years in relation to trusts. So when I started practicing back in the late 1990s, and particularly through the first decade of the 21st century, trusts were being set up left, right and centre. So pretty much everyone who came into the office was looking for a trust for one reason or another, because their accountant told them they needed one, their best friends had one, everyone in the cul-de-sac had one as well, and that's something that they thought they should be doing too. So lots and lots of trusts set up. But then in 2019, when the new Trusts Act was enacted, came into force in January 2021, there became a lot more things that people had to think about with their trusts, a lot more rules around how a trust should be run, and that's when people started thinking, actually, is this the right structure for me? So things that the Trusts Act has done is it's really raised the bar for trustees. So best practice, having professional trustees, not necessarily the legislation doesn't require that, but that helps with all the things that the legislation says need to be considered now if you're a trustee of a trust. There's also a heightened accountability to discretionary beneficiaries, which for some people that was terrifying in itself. Do I have to tell people what's in the trust? The beneficiaries have to know? And so clients that came into our office, and excuse me for those of you who would have heard me say this before, but varied from don't care, we're really transparent with the children, this is all part and parcel of who we are and how we operate, down to hell no, don't want the kids to know anything that's in the trust. And the ones in the middle were sort of more like, don't really mind if my children know, but wouldn't want their boyfriends, partners, spouses, girlfriends to know what was in our trust. So quite a varying reaction to that new requirement under the Trusts Act. Increased administration and compliance costs, and I think this isn't necessarily a direct result of the legislation, more that because of the way the legislation is structured with default duties and legislated obligations of care for trustees, people are a lot more wary of being a trustee and want to ensure that they're actually doing it properly. And so with that comes cost, because obviously if you have a professional trustee, we don't work for free, usually. So there does come a lot more cost and compliance. And so there becomes that cost-benefit analysis of, does the cost that the trust is creating actually, is that in balance with the benefits that the trust is providing us? So many trusts set up 20 to 30 years ago, and as I mentioned earlier, and the set law circumstances might have changed, which I'll talk about in a minute. So these are all the things that people are thinking about when they're thinking about whether they've got a trust or whether they need to have a trust. But sometimes trusts are the best fit. So before I talk into the reasons why you might not have your trust anymore, there are still some really good, valid reasons for having a trust. The first of those is the age-old reason of creditor protection, and very, very simplistically put, but my assets are over here. If I get sued, my assets are over here in this trust, and so they're not my personal assets, and so they can't be touched. Now, we all know that's not exactly true, but it's the best way really of explaining what creditor protection is. In all my years of practice, I think I've probably had more than 10, less than 15, so let's say a dozen clients in all those years who have had to rely on their trust because something has gone wrong within their business. And every single time I can tell you that their trust has protected in some way, shape or form. So it might not have protected absolutely, as in they might not have been able to just step away from the whole situation and say, everything's over here, but it's been able to give them choices as to how they want to deal with those situations that they're in. So a little bit like insurance, isn't it? So that you take out your insurance, you hope your house won't burn down to the ground, but if it does, it's there. And so you might think that 12 people in all those years is not many. I think that's great, that it's only a small number like that, but I can honestly say that, yeah, a trust has helped in every time. Relationship property. So trusts are not a panacea to all ills when it comes to relationship property. So when the new Property Relationships Act came into force in 2002, trusts probably were seen as a way of putting your assets into trust before a relationship to make sure that they were protected if you got into a relationship and that relationship didn't go well. I won't go too much into this because I know Stephanie's going to be talking about what happens if you do separate. But while trusts are not the belts and braces as far as relationship property is concerned, they do speak a language of separate and protection. So people do understand that a trust is not your property, and particularly if you're talking about children and you've got assets within a trust and you're worried about what spouses and boyfriends, etc., girlfriends might think about your trust assets, the protection that or language that a trust speaks around these are separate properties, it really helps having some of those conversations. And we'll talk about that more when we talk about helping children into property. Trusts do provide really good flexibility in blended family situations, which is something we're seeing more and more of. So that's where you come into a new relationship and you have been in previous relationships and you might have children from those previous relationships. And trusts provide a really flexible vehicle for dealing with those situations, not so rigid as some other structures that we know. Trusts are still one of the most flexible vehicles that we know, so they can be really well used in those blended family situations. Tax flexibility. So even though there's quite a bit of negative publicity around the trust tax rate increasing to the top personal tax rate of 39 cents, there's still a lot of tax flexibility with trusts in that you can allocate income out to beneficiaries at their lower rate. So I won't go into that in too much detail, I'm not an accountant, but there is still great tax flexibility with trusts. They are very good like that. Intergenerational wealth planning, so that's thinking about assets that you want to retain long-term for your family. Sometimes it's because you've got a great lot of wealth and you want to provide for future generations. Sometimes it's a family holiday house that you want to keep for future generations and you want to have it in a particular structure that's got flexibility and longevity, or it might be shares in a family business and the business is doing well and you want to be able to provide income to future generations. So that's reasons why people also set up trusts. And lastly, estate planning flexibility. So a will can be quite black and white, whereas a trust has got some flexibility. And I was talking to clients about this afternoon. I was in a meeting in a trust situation where someone had passed away, and there were wishes, memorandum of wishes there, which is like wishes to the trustees as to what happens if you die. And the changing dynamic of the family meant that perhaps the wishes shouldn't be adhered to exactly, because the trustees' discretion is such that they can consider the wishes, but if things have changed, they can do something different. Whereas if what the person who died wanted, if she'd put that in a will, it would absolutely have to be followed to the letter, unless everyone agreed and there was another arrangement, which is tricky to navigate. So trusts do give quite a lot of flexibility in estate planning. Another example would be if you had a child who was bankrupt or had difficulties, maybe addiction type difficulties, then having your assets in trust means that if something happened to you, those assets could be distributed in a more measured way rather than directly to that child who might not use them appropriately. So sometimes trusts are the best fit, and it does depend on your circumstances. However, on saying that, we have a lot of people winding up at the moment. Part of that is because some people have got trusts who probably never should have had trusts. So it might just have their family home in it, for an example, and they did it because everybody else in the cul-de-sac did it. But there could also be reasons just because life's moved on. And one reason is simplification. Oftentimes as people get older, they don't want the complexities of a trust anymore. They don't want to have to involve someone else in the decision making. They just want everything pared back and simple. And often it's because they've got to a stage in their lives where asset protection may no longer be a key driver for them. They might have sold their business, their kids are really settled, they don't need to have that ring fence around their assets. So that's probably the predominant reason that we see for people winding trusts up. You will have heard me say this before as well, but I'll say it again, that trusts sometimes can be like life insurance. So when the children are little and the debt's big, then you need more of it. And as the children grow and the debt shrinks, you need less of it. And trusts can be like that too. So there's times in your life where you might need two trusts because you might have business risk over here and your lifestyle assets here. But then there might be times in your life when actually you've sold the business, so you need to get down to one trust and then you want to simplify again. I'm going too slowly. I need to speed up a little bit. Trusts are often looked through in rest home as subsidy applications. So back in probably the late 1990s, early 2000s, a lot of trusts were set up because at that time policy was that if you had your assets into a trust soon enough, then those assets wouldn't count, the ones in the trust, if you had to go into rest home care. And that's really not the case anymore. So they do look through trusts mostly for that. And I'm happy to answer questions at the end about that because I know that can be a hot topic. And then once again, the ongoing trust administration costs, which we've just talked about, have probably increased since the Trust Act came into force. So there are things that you can do with your trust. I'll just skip lightly over this because I really want to get to powers of attorney, and I've only got 1 minute according to our time schedule to talk about that, and that's my favourite thing. So if you've got a trust, you can review the trust deed for modernisation. Highly recommend that. Check who the beneficiaries are. In the old days, we had really wide classes of beneficiaries. Nowadays, we have much narrower classes of beneficiaries. Check who the trustees are, how they're appointed, what happens if one dies, what happens if one loses capacity. And a big one is where are the beneficiaries situated, because there are a myriad of new laws in international jurisdictions, tax laws, which means that sometimes your New Zealand trust passing out to a beneficiary in an overseas jurisdiction, thinking namely Australia, the US, the UK and others, and they will be taxed. Your beneficiary will be taxed in that jurisdiction as if the capital that you're passing through from your trust is income to them in that jurisdiction. That's huge. There's quite a lot that we can do around that, so if you've got that looming in the back of your mind, then definitely need to get advice on that. It's become a really big deal. We could do a whole hour, if not longer, on that. Okay, I'll just skip over this slide. It's just talking about the things that we look for in trust deeds. Can you vary it? Can you resettle? So if we can take questions on that at the end. Okay, my favourite topic, enduring powers of attorney. So enduring powers of attorney come into effect, well, they don't have to come into effect just if you lose capacity, but that's how we think of them. So if I'm not able to act for myself, then I appoint someone to act for me in relation to my property, and a separate document, not necessarily a separate person, to act for me if I can't make decisions around my own personal care and welfare. So property, you can have that come into effect immediately, and then it only it doesn't kind of expire, if you like, if you lose capacity. So an example of that, in fact, I think we had a situation today in the office where we were talking about someone who someone who'd had a stroke, was in hospital, mentally fine, but physically wasn't able to sign things, and her son had called up just wondering, how that worked. And so if the person had picked the property to come into effect immediately, the property power of attorney, then her son, who had been appointed, would still be able to sign things on her behalf if she was mentally capable. But if it just said only mentally incapable, he wouldn't. Personal care and welfare only comes into force if you have lost capacity. So if you can't make decisions for yourself and you need generally a doctor's certification for both to invoke a power of attorney becoming operable if someone's lost capacity. I recommend these to everyone, so regardless of age or stage. I think we've often thought about elderly people needing these when they're starting to wobble a little bit. Everyone, any one of us at any time could have an accident, could have a stroke, and if you don't have someone appointed, then this says it all: cost, delays, controversy. So if you don't have someone appointed as a power of attorney, you have to make an application someone has to make an application to the court. You can't, because you're incapacitated, but someone has to make an application to the court to be able to act on your behalf, and it might not be the person that you want. So it could be a child, and actually you would prefer to have had the other child. It could be two children who then start warring about who's going to do the job for mum or for dad. It could be new partner, children from previous. So there's a whole myriad of different personalities who might want the job, and then guess what happens? Everybody gets a lawyer. A lawyer's appointed for the incapacitated person. That has to happen. You need a doctor to fill out a particular form. Then you need, so you could end up with multiple lawyers. You go before a judge if it's not straightforward. It takes a long time to get court dates at the moment. So that could be, it could be a 6-month process to even just get to see a judge. Yeah, it's expensive. And then going forward, you need to renew that every 3 years if it relates to property. And also you need to report to the court with statements on how you've used that person's money. So the whole thing costs a lot of money and takes a really long time. So much, much, much simpler to put in place powers of attorney and have those ready as your insurance, hoping this will never happen, but just in case. Can't stress it highly enough. Wills, I'll just do this really quickly. So wills, if you don't have one, there are potential issues. So if you die without a will, there actually is rules that we have to apply to your estate under the Administration Act, which says how your assets are to go. So it depends how. I think there might be something on our website that a link. If you need to know, we can send you a schedule which shows what happens if you die without a will. Preference is to get a will. Unlike powers of attorney, where if you lose capacity without powers of attorney in place, you have to go to court. You don't with your will, but it won't go how you want it necessarily. So you need to plan for your current circumstances. That's my other advice with wills. Don't think about, what happens in in 5 years' time, if we decide to do this, or we sell that property, or we have fallen out with this child, or plan for what your situation is now, and then review it. So review it if your life changes, or every 2 to 5 years. Lawyers would love it if people review their wills every 2 to 5 years, because circumstances do change. But you do need one at every stage of life. KiwiSaver, that's a big thing, young people with KiwiSaver. If you've got assets of more than $15,000, we need to get probate to be able to get that money out of the KiwiSaver provider. And if you don't have a will, you might not know where that's going to. That's about to change for KiwiSaver. That's actually gone through, hasn't it? Yeah, about to change.
Yeah, so the threshold has gone up, and it's going to be 40,000 rather than 15.
But $40,000 only for KiwiSaver and insurance proceeds. So if you've got $40,000 in a normal bank account, we still will need to, less than $40,000 in a normal bank account, we'd need to still get probate. But wills are very important as well. So sorry, I took too long, Steph, but I'll just segue through to you.
No trouble. Yeah, so look, I'm going to talk a bit about navigating separation and divorce, and Tammy commented that it's somewhat unenviable, but it's actually an area that I'm quite passionate about, and the reason for that is that it can be one of the most difficult things that someone goes through, and in that context, we can really help to guide, advise, and give a bit of a roadmap to what the process is going to be like. So look, this is a huge topic. This topic could be multiple seminars. So in deciding what to talk about, I thought that just sort of setting out the roadmap might be useful for a new client that comes to see us who's at the start of the process. It's really the uncertainty of what on earth is going to happen next, and what is this going to look like. So just being able to set out, okay, here are some of the markers along the way, can help give a bit more sense of control back. So the first thing is both parties are going to need an independent lawyer. It can't be two lawyers in the same firm, no matter how amicable and on the same page you are about the separation. We just can't do our job to independently advise each of you. So the starting point is that both parties do need independent lawyers. So then, once the lawyers are instructed and we've made contact with each other, the first piece of the process is what we call disclosure. So that is where each party puts on the table, these are the assets and liabilities in my name. And that has to be a fulsome disclosure, and it will include property that is separate, which we'll come to in a moment. But it's really just making sure that both parties are fully aware of everything. And when it comes time to sign an agreement, each party is warranting that, yes, I've given disclosure of everything, that there isn't a secret bank account hidden away. And so for some people, there aren't any surprises in that. But for others, if it's been a long marriage and you've divided up the roles and, you've kind of taken your finger off the pulse in terms of the accounts and what happens, then that can be empowering to get that information, so that you know exactly what the assets and liabilities are. And also really important for both of the lawyers to understand, okay, this is the asset pool, in order to be able to advise on, okay, what are the entitlements here, and what are some of the kind of options that, we could look at in terms of a division. And from there, usually one side presents some sort of proposal to the other. Sometimes there's a bit of back and forth around the extent of disclosure, or about certain principles, and I'll come to that. But generally, you start with a proposal. There's a bit of back and forth, and hopefully without too much delay and cost, an agreement in principle is reached. And from there, one of the lawyers will draft it, the other will review it. and once the agreement is signed, then it can be implemented. So often, that might involve sale of a house or transfer of one party's share of the house to the other. And so that's, a bit of a job for us to do, and often or sometimes one party needs to raise some finance to settle that, so we need to make sure that the agreement is workable in terms of timeframes so that you can get the assigned agreement to the bank to get the finance approved in time for settlement. So that's sort of the roadmap. Of course, some matters don't go so smoothly. Sometimes, or just in terms of time frame, this could be done in a 2-month time frame, or it could be years on end. There's just a lot of variables there. One being sort of the ability of the parties to see eye to eye. Do they see things the same way? Have they already talked amongst themselves about how it's going to go? Or is there a stalemate for whatever reason that it's just really difficult to get an agreement? Also, sometimes just complexity around the assets. If there's a business or a property that has issues with it, some of these things can really just extend out the process. And in rare circumstances where an agreement can't be reached, then eventually the last resort would be to go to the court. But before then, doing a mediation or some sort of alternative dispute resolution is also an option. So I thought I would cover off, relatively briefly, just a few of the key principles that sort of govern what your entitlements are in terms of relationship property. So the Act sets out what is separate property and what is relationship property. And generally speaking, your separate property is going to be inheritances and assets that you've brought to the relationship and not then used for relationship property purposes. So, the big one here, which I've mentioned there, is the family home. If you've come to a relationship with a bit of a nest egg, put it towards a property that you live in with your partner, then that's going to lose its status as separate property and become relationship property. And similarly, with a family home, if you've brought the home to the relationship, that home also becomes vulnerable if a partner moves into the property and it's a qualifying relationship under the Act. So in terms of division, the starting point that the Act sets out is a 50-50 division. And the Act is or recognises strongly non-financial contributions to a relationship. So the premise is if one party is out, working 9 to 5, and the other party is home, looking after the children, keeping house, doing that sort of huge role at home, then they've contributed equally to the relationship. So some of these principles will kind of seem fair for some relationships and not others. A really important part of the Act is the ability to contract out. And I'll talk a little bit about that in terms of new relationships. So in terms of departure from 50-50, one of the principles is around economic disparity. So in the situation that I mentioned, where you've got one party who's out working and the other party who's home, raised the kids, if that person has had, 10 years out of work, then the day after the relationship, their earning capacity to go out and get a job is going to be a lot less than the one who's been career building. So in those sorts of circumstances, there's the ability for there to be an adjustment in favour of the person who's been taking on the home front out of the relationship property pool so that they end up with more than half. Another thing which is often quite relevant in negotiations is the notion of occupational rent. So quite often when the separation takes place, one party leaves the family home and they find a rental or they're living elsewhere for a period of time while the parties are working through this process. So the idea is that whatever the market sort of rental value of the home is, half of that amount would be charged back and taken into account in terms of the division of property. And in terms of exceptions to 50-50, where there's a 60-40 or a 70-30 split, the situations that would give rise to that are relatively rare. So in terms of the conduct of the parties, who said what, who did what, when, generally it's just not relevant. It's a pretty high bar to meet to say, my ex-partner acted so badly and treated me so badly that it should be other than a 50-50 split. So yeah, it's a very extreme circumstance that would lend itself to that. The Act talks about it being a serious injustice for a 50-50 division. So it could be conduct of the parties or things like, a qualifying relationship in terms of length, more than 3 years, but a relatively short relationship. Maybe there's sort of wholly inherited property, a 4-year relationship. This sort of extreme cases where the court would go, look, that's just so seriously unjust that I'm not going to order a 50-50 division. And so at the end of that, and coming back to our roadmap, the settlement has happened and, you've either got the property or you've got some cash and you're going, okay, this is now my asset pool, what next? So hopefully at that point your lawyer will say, let's take a look at your will and your enduring powers of attorney. So if you get divorced, your will doesn't cease to apply. And so often people have a will that would leave everything to their ex-partner. So just really important piece of the puzzle to make sure that you update that at the time. And similarly, your enduring powers of attorney, you might not want your ex-partner making your health decisions going forward. And then, of course, it's, the time will come for new relationships. And so qualifying relationships, there's this 3-year period in the Act. The 3 years, even though the Act says living together, it doesn't really mean living together, and so that 3 years can start quite early on. So we'd always encourage people to think about a contracting out agreement sooner rather than later. One, to make sure that you kind of get in there before you hit the qualifying relationship marker, but also just in terms of the ease of having the conversation and the sort of bargaining position that you have. It's a lot easier to have that conversation when, you might both be fresh out of going through the separation process versus, a couple of years down the track when you're living together and everything's going well, becomes a bit more difficult to raise. So it leads me on to buying property with a new partner, which is often when someone will either want a contracting out agreement or need to do an update to it so that the new circumstances are covered. So, the main point around this is that if you're both contributing to a new property together, you'll both want to protect your contribution to that property. Often the contributions are unequal. And so a contracting out agreement says, forget what the Act says and what the law says, this is what we agree. If we separate, then we'll get our contributions back and, it can say whatever you want, but, typically get our contributions back and we'll share any capital gain in these proportions. One thing that's important is that contracting out agreements, it doesn't just deal with if you separate, it also deals with if one party dies. And so if you've if you've got children from previous relationships, then contracting out agreements are really important, to protect your children's future inheritance, essentially. So in terms of ownership, there's 2 ways to own a property with someone else. If it's joint, John and Jane, then if one of them dies, then the other one owns the whole property. It doesn't form part of the estate. The other way to own it is tenants in common, so it could be Jane's half, John's half. And that would mean that if Jane died, then John would still own half, and Jane's half would be owned by her estate. And so then we'd be talking about, does John, in that scenario, is Jane going to give him the ability to continue living in the property for a certain period of time, so having a life interest or a limited interest, but ultimately making sure that Jane's estate is able to, or the terms of her will be able to pass her half share to her children or whatever she wants to do in her will. Speaking of adult children.
Okay.
Oh, yeah.
Okay, back to me. One thing I would just add is that I often say to clients too, if the law was black and white, particularly in that relationship property area, you wouldn't need lawyers. You just apply the law and away you'd go. So there is quite a bit of grey kind of down that band of 50-50. So such an interesting area. Okay, so helping adult children into property. So there's various ways that people can do this, and I just thought I'd canvass what those are. So the first one, to be honest with actually, let me just say before I do that, sorry, conversational, but let me just say before I do that, sometimes I think people have this feeling these days of a moral obligation to help their children into property that has probably never been felt before until these times where we've had skyrocketing house prices. And sometimes that does worry me, that people, even, whether they can afford it or not, feel a social pressure to help their kids into property. So my first piece of advice is don't feel that. Anyway. So that's the life advice, not the legal advice. So the first way of helping people children into property is to guarantee their borrowings. Now, I do have to say this is something which doesn't happen quite so much anymore, and part of that is just the way that banking has evolved over time. But it used to previously be quite a common way of helping kids into property, is that you had your house and you had equity and they had a small deposit and that was it, and you could put your house up as security as well as their house. They would still borrow the money, but you would guarantee it, which would just mean that if they couldn't pay, the bank would look to you to pay. It doesn't happen as much as it used to in that kind of scenario, where it is more likely to happen if there's co-ownership, which I'll talk about shortly. But yes, what is a guarantee? It's basically that. So Steph owes some money to the bank. She hasn't got either the security or the serviceability to pay the bank what it needs to, but actually do it the other way. I don't have enough money. Steph's guaranteeing me, and so if I can't pay, Steph will pay, and the bank will look to her. The things to remember are that when you enter into a guarantee, it's as if you were the principal borrower. So if there's a default in a payment, the bank can go to the guarantor first before it even goes to the person who has borrowed the money to ask for payment to be made. It usually doesn't happen like that, but that can happen. You need to check to see whether the guarantee is an all obligations guarantee or whether it's limited to a certain amount. So all obligations means that it's all obligations that the person that you're guaranteeing has to the bank. So if I guarantee Steph's borrowings, Steph then guarantees her partner's business borrowings with the same bank, I've effectively guaranteed Steph's partner's business borrowings with an all obligations guarantee. I've also guaranteed if Steph pays down some debt and then borrows a chunk more, I've guaranteed that as well. If it's a limited guarantee, it could be limited to a facility or an amount, and that kind of fixes your obligations under the guarantee. One thing to really remember is banks don't voluntarily release guarantees either. So unless you ask the bank to release a guarantee, it will sit there forever. So really important that if you think the person has paid down enough debt or their equity has grown enough because of house prices increasing, that you go to the bank and ask for that guarantee to be released. You need to get independent legal advice. There will be situations, so for an example, if a trust is guaranteeing the borrowings of the settlors, then often that independent legal advice is waived. But in the situation where you've got a parent guaranteeing the borrowings of a child, then there is an insistence on legal advice being independently given. And harking back to what Steph said, that doesn't mean a different lawyer within the same firm, it means a whole different firm of lawyers. So that's really important. The other thing to consider too is if you are providing a guarantee to your children, that you ask them for an indemnity. And what that means is that if I've guaranteed my son's borrowings from the bank, he can't pay it and the bank comes to me, that we have a separate contract, him and I, where he agrees that if the bank comes to me, that he will pay me back for whatever I've had to pay on his behalf. Sometimes lawyers say they're not worth the paper it's written on, because if the person can't pay, the person can't pay. But that's something that I'd definitely recommend getting, would be an indemnity. Gift. So often people talk about gifting money to their children and they really don't mean it. What they mean is a conditional gift, which is really a loan. But when you're gifting money to your children, that if you gift money to someone, doesn't have to be a child, but to anyone, that you can't ask for that back. It's not a loan. You can't ask for it back, so it's gone. You don't expect it back. So to be honest with you, not many people really want to do a full gift. They want to do a gift kind of because they don't want interest to be paid on it and they don't really expect it to be paid back. But if the child then borrowed a whole heap of money and from the bank and went overseas and spent all the equity in the property, then the parents actually are like, I'd rather you paid my money back that I gifted you first. Or if the parties separate, so if you lent money or gifted money to your daughter and her boyfriend is living in the property, then if they separate, then you actually want to protect whatever you've gifted to them. So when you're thinking about these things, relationship property protection is another thing to be considering. My point down the bottom of Beware the Bank is that very often, we will get clients whose children are buying a property and they've been given a deed of gift by the bank or their mortgage broker, and they want to sign it because that's kind of a condition of their child getting the loan. But if they sign that deed of gift, that actually would be a legally binding document which says that they've gifted the money to the child. So be very, very careful about signing those, because there are other things that we can do which will satisfy the bank that you don't want the money paid back, because all they want to know is that you're not going to put a mortgage or caveat on the property, that you're not going to charge interest because that would be taken into account with the child's serviceability, and that you're not going to ask for the money back the following week and then the child is stuck. So there are other things that we can do. The other thing that under general law, there's a principle that if I gift money to someone who's not my family member, so if I give some money to Steph, because we're not related, there's a presumption that that's actually a loan, unless it's documented as a gift. Whereas if I gift or give some money to my child, the presumption when it's a family member is that it's actually a gift if there's no document there. So it's really important to be very clear in your head what you're trying to achieve, and then document correctly what you are wanting the outcome to be, particularly if you're gifting, lending, whatever, to a child who's in a relationship, which I guess is really what we're kind of thinking here, that you have to be really careful with how you do that. So definitely get advice if you're not sure. Don't sign anything that says gift on it without getting some legal advice and really knowing what your intentions are for that money. The most common way of helping children into property, and probably one that we would encourage the most, apart from the last thing, which I'll talk about last, is a loan to a child. So this actually could be your conditional gift situation, which, as I say, is an oxymoron. It is a loan in that case. So you might be wanting to help your child. You don't really want the money back. You don't want them to be paying interest on the outstanding amount. but you might actually want it back in the event that they separate from their partner or they decide to sell the property and just go and spend the money on a cruise around the Mediterranean. So that's where you would document a loan to the child. Loans can be really simple, really straightforward. They don't have to be anything overly complex, but there are some key things that you need to think about. And one is, who is the loan to? So if I lend money to, I'm going to say my son, he's 15, but if I lent some money to my son and he's buying a new property with his girlfriend and they're buying the property together, if I just lend the money to him, then his girlfriend will think if they split up, she takes her half, he takes his half and has to pay me back. And I really want the money back from both of them first. So you need to think about who the borrower is in your loan. And it sounds counterintuitive to lend to the couple, but that's your safeguard in making sure that there's an understanding that the obligation is for them both to meet that repayment. You need to think about what the conditions are around the loan. So it might be that you want the child to keep paying into KiwiSaver. I had a grandfather who that was one of his conditions, is that the child kept paying into KiwiSaver. It might be that it's a loan in respect of this property, and if this property is sold, it needs to be repaid back. It might be a loan on the basis that they don't borrow any more money from the bank as their equity increases in the property. So you can put whatever conditions you like in there, provided that everybody agrees to what those conditions are. You need to think about whether the loan is going to be interest-free or whether there's going to be interest calculated on the loan and repaid to you. So you do need to think in that instance, if interest is going to be paid back to me, that's actually a taxable source of income, and so you would need to pay tax on that. Some people have the idea where, and I'm not an accountant, so please take accounting advice on everything I say about accounting stuff. Some people have the idea that I'll lend you this money and I don't pay me any interest, but when you sell the property, I'll take a little bit of the equity that's been gained in proportion to what I've lent you. That's also income. So you need to take accounting advice on that arrangement as well. Payable on demand, that means when is the money payable? Can I demand it at any time? If I need the money back, if I want to go on the cruise around the Mediterranean, can I write a note to my child and say, actually, I need the money now, please, can you pay it back to me? Or is it just payable in certain circumstances? You also need to think about security. So some people do want to make sure that, particularly if it's a large sum, that they have got the option to be able to put a mortgage on the property. Obviously, if there's a first mortgage on the property to a trading bank or another financier, that's an arrangement which needs to be thought through as well. So these are all the things that we talk about when we're thinking about lending money to children. And I encourage you to think about lending it rather than gifting it. The last way of helping your child into property is taking a share in the property. And I think the most common scenario here is where you've got children and parents going to be sharing the same property. And it's not an uncommon thing where parents and children decide to pool their resources. Maybe mum and dad sell their house and put the money into a new property which has got, excuse the phraseology, but a granny flat, because that's what it used to be called, but a home and income type property where parents are living in part of the property and children are living in the other, and so they'll come together and purchase a property together. Oops. So there's a few key things here, is that often in that scenario that I've just talked about, it's the parents who have got most of the money, and it might be the children who have to take a loan out. But under the responsible lending codes now with the bank, if you've got mum and dad and children on the title to the property, the bank will require everybody to be a joint borrower. So they won't just lend to the children if the property is in mum and dad's name as well as the children. And the reason for that is because of the responsible lending code, where the bank doesn't want to go to, let's say, a 70-year-old parent and say, your child hasn't paid their loan, and so we're going to have to sell the house at mortgagee sale. That's an extreme example. So they want the parents to be borrowers as well, so everybody's joined in together. So that's something that you need to think about, and there's things that we can do. So we can do that indemnity that we talked about before. So that's where you have a separate document behind the scenes saying, I know we're all in this together on this loan document, but actually it's actually the children who are the borrowers, and if the parents have to pay the children are fully responsible for the loan. If the parents have to pay anything, the children will pay them back. So there are things that we can do there. The other thing that you need to think about is bright line test. We did have some clients who did get caught. I'm just actually scanning to see if they're here. I don't think they're here. Who did get caught? Well, not really caught. They knew what they were doing, but they had gone into a property purchase with their daughter, and they had shares in different proportions. And the idea was that as the equity grew, she would take a greater share. And at the time where they wanted her to take a greater share, and they were going to get some money out, we still had the 10-year bright line test, and so their share was subject to the bright line rules, and they had to pay tax on the increase in value of their share. It's still a major consideration, but with a 2-year bright line test, it's obviously not quite so painful, or you could structure in a way that you could think, well, actually, I know that I can't do anything with that for 2 years until I've owned the share in the property for 2 years. But that in that case, it wasn't going to be the main family home of the parents. It was a helping way of them helping their children into property. One thing that we would highly, 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 highly recommend is a property sharing agreement. And we see it go wrong a lot when families say, we never have arguments. Everything is just so wonderful, and this is going to be so wonderful, and we know this is going to work, and they don't do anything, and it just all can turn to custard all around them. So a property sharing agreement is an agreement that everybody enters into, and we would encourage independent legal advice, absolutely, and it will say things like who's responsible for the rates, who's responsible for the insurance, the other outgoings, who's responsible for any debt on the property, what happens if somebody dies, what happens if somebody separates, what happens if somebody says, actually, this isn't working for me anymore, I want out. You can have all those rules set out in your property sharing agreement, and that will it will pave the way so much more smoothly for you if something goes wrong. So a little bit like powers of attorney, a little bit of upfront spend, which seems at the time when you're buying a house, oh my goodness, another cost. But boy, it'll save you some legal costs at the end if it all goes to custard, that's for sure. Okay, and lastly, just wills, sorry. Consider the impact on your will if you're lending or gifting to one of more than one children that you've got, because can you do the same for everybody? Do you want to do the same for the other kids? Do you want the money to be paid back into your estate if you die? Do you want it to be taken into account as part of what your child would be receiving from your other assets? Do you want to equalise with your other children? These are all the things that you need to be thinking about in the context of your estate in the future, because if you've thought about them first and have a clear plan of what you want, you will save so many arguments and legal fees at the end, and like this as well as the relationship property Steph was talking about, it's true what they say, it's the lawyers that win at the end of the day with the legal costs when things all turn to custard. And it's not just the cost, it's the emotional cost in the family as well. It's terrible. So the other things to consider when you're helping your kids into property.
All right, so guiding ageing parents. A couple of things I wanted to talk about here, and the first is around acting as attorney under an enduring power of attorney, and then secondly, what to think about when looking at moving into a retirement village. So acting as attorney, so the way that enduring powers of attorney are created, as advisors and lawyers, we have a lot of quite strong obligations to make sure that we give a really thorough explanation of how the documents work and what it all means to the person creating the enduring power of attorney. But the person who's nominated as the attorney in the document, they just sign and there's no real advice given often from their own lawyer. And so often it's not until the time has come that actually, okay, I need to perform this role, that you start thinking, oh, actually, what do I do here? So my top tip actually is the enduring powers of attorney themselves. They're very long documents, and it kills a lot of trees, and people get overwhelmed by them. But in that document, there's about 5 pages of notes, and I think they're actually really good notes. And so that would be, my starting point is, look, have a read through the notes, and that might answer, some of the first questions. So look, the role of the attorney is really, in terms of personal care and welfare, I guess that's sort of the more simple one. Making decisions, working with the doctors to make medical decisions and decisions about the kind of care that the person needs. And, it can also be working closely with staff at retirement villages or in sort of care homes about care plans. The more tricky one is around property. So the role of the attorney in that case is to manage the person's property in their best interests and in accordance with their wishes so far as you're able to, for the benefit of that person. So the extent of the authority, unless the document restricts it, which it might, then the authority is sort of total. You can take the enduring power of attorney to the bank, access bank accounts, sell a house, do anything with the property that the person could do before they lost capacity. So when enduring powers of attorney are activated, this is what Tammy talked about before, that there's a choice when it comes to property. Is it going to take effect immediately and continue if I lose capacity? Or is it going to be only if I lose capacity, in which case a capacity assessment from a doctor would be required? It's case by case what works for everyone. Certainly in the case of someone who has is more elderly and has their adult children slowly doing more and more things for them, having it take effect immediately and continue can be quite useful, because it could be that the person still has capacity but they're just not up to doing all of those admin tasks that they once did, and they've got their children sort of helping out more and more. So the documents can also include in there a requirement for the attorney to consult with someone or more than one person, or to provide information to someone. So in terms of what the attorney needs to do, they have quite a lot of obligations. So, the first thing is really to know the document. Are there requirements in there to be consulting with anyone or providing information to anyone? Are there restrictions in there, or any special conditions or extra authority? So at a starting point, you can't benefit anyone else or yourself when you're acting as attorney, but there can be special provisions in there, which we often recommend, that a spouse, if they're acting as attorney for their spouse, can benefit themselves so that they can continue their lifestyle as it was immediately before the loss of capacity. So having a good handle on what the document says and whether there's any special clauses to be aware of is really important. Record keeping. So for an attorney in relation to property, there is a statutory requirement to keep a record of all transactions entered into on behalf of the person, and failure to do so can yield a fine of $1,000. So that's important to be aware of and not really sort of flagged or discussed much. So in terms of benefiting yourself, as I said, you can't pay yourself for your time, and look, it can be a really, really big job depending on the extent of the assets, the family circumstances, but unless the document has the specific ability in there for the attorney to be benefiting themselves, then there just is no ability other than to reimburse any out-of-pocket expenses. And as Tammy mentioned before, if there isn't an enduring power of attorney and you've been appointed by the court as a property manager, then you've got additional obligations to report to the court at regular intervals. So I'm aware that it's 7, so we're just going to go over quickly about moving into retirement villages. So for a lot of our clients, I mean, they might have bought and sold houses, for years, but when it comes to moving into a retirement village, it's just a totally different kettle of fish. So what you actually buy, in quotation marks, is a license to occupy. And when you advance the money, it's an advance, essentially a loan to the village, and what you get in return is the ability to occupy a particular unit. So, look, there's a statutory scheme around this which does provide a bit of protection that the advance that you give will be protected. And so what's really important is to make sure that the village that you're looking at is a registered retirement village. If it doesn't, then it's not going to have those protections. I've set out there just a few things to be aware of in terms of cost, but really the main point here is that all villages are different, and things also change over time. So these points are really things to think about and questions to ask, rather than this is how it will work. So usually there would be a weekly fee payable. And important to ask, is that a fixed weekly fee or is it subject to increase in the future years? And if it can increase, is there a cap on that? Deferred management fees. So this is kind of the chunky one. So when I mentioned before that when you buy in quotation marks, when you advance that money, when it gets repaid, the village clips the ticket on that, and it's typically about 30% that is retained by the village as the deferred management fee. And so that is, oftentimes it's when the person passes away, but it also applies if you wanted to leave the village and move on. So because of the way that cost structure is set up, it's really important to get the right village at the outset. You don't want to be moving every few years. And actually, just another plug for enduring powers of attorney. Villages will require there to be enduring powers of attorney in place before someone's allowed to move in. This fee structure, you might have picked up on it, it's not a financial investment to move into a retirement village. What you're paying for is, the community, the support and everything, that goes with it. So, sorry, I'm kind of rushing through because we're over time. When it comes to choosing a village, as I said, it's important, to get the right village. So a few things to ask, and what's really important is continuation of care. So, when you or your parent moves into a village, they might be quite happy in an independent unit. But what if, a few years down the track, they need more support? So ideally, some villages have independent units, they've got the sort of, residential suites with a bit more care, but also then the hospital care. And you might also want to have a think about dementia units as well. Development plans, it's a bit like buying a house in this sense. Is there plans for a massive new building next door and there's going to be construction every day for the next few years? Visiting multiple times, get a good feel for the place. The sales managers at the villages, are useful just to have a chat about what village life is like, and they can give you that sort of information around and fees and that. When in terms of the documents and the process, you do need to see a lawyer to sign up, and so and we do spend a lot of time making sure that the person understands exactly how the fee structures work, and all the ins and outs of the contract, just making sure that the person fully understands what that is. So that brings us to the end of our content, and I'm aware that was quite the whirlwind. So in about a minute, we will begin a brief Q&A, so get your questions ready, and we'll have a microphone circulating. But before that, I just wanted to introduce the rest of the team. It's not just Tammy and myself. So we've got 3 other lawyers in the team, Holly, Kirsty and Ella, and then we've got 3 very experienced legal executives, Deb, Gail and Teresa, and they're right down at the back in the back row. Do feel free to say hello. And as a reward for staying until the end, thank you. If you have an orange sticker on your handout on your chair, then we have a little spot prize for you.